Good afternoon and welcome to December's interactive webinar for special education surrogate parents presented by the Recruitment Training and Support Center at the Federation for Children with Special Needs. My name is Janie Kreco and I am the Training and Support Specialist at RTSC. If you are interested in learning more about the Federation, please go to our website at www.fcsn.org and explore all the different programs and training opportunities. Our presenter today is Brenna Williams, Senior Staff Attorney at edlaw. The edlaw project is an initiative of the Children's Law Center of Massachusetts and the Committee for Public Counsel Services, the Children and Family and Youth Advocacy Division. And I believe that Brenna will tell us a little bit more about her services and the edlaw Center. Our IT director today is John Sullivan. The webinar is being recorded so that those who could not attend can retrieve it on our website at a later date. Some technical pointers again, everyone but the presenter will be muted so that background noise is kept to a minimum. If you have any questions, please use the toolbox to submit them on your screen. I will be watching the questions and will present them to Brenna as time allows. And then lastly, before you sign off of the webinar or as you sign off, could you please complete our 3-question survey because it does have to do with the teleconference on Thursday. Okay, Brenna, are you ready to go?
I sure am.
Alrighty. Welcome and thank you so much for being here.
Thank you for having me. As Janie said, I'm a senior staff attorney with the edlaw project, and we are a legal service agency that has been in existence for about 11 or 12 years. We are an initiative of the Committee for Public Counsel Services as well as the Children's Law Center of Massachusetts, and we both of those agencies represent youth in a variety of different court cases, including delinquency, care and protection, and CHINs, and we work with them and are a project of those agencies because they know that students who are involved with those cases more often than not have issues in school, and so currently we are working to equip and support attorneys that practice in the juvenile courts to advocate for their clients in schools, because we believe that effective advocacy in the schools will help their underlying court case. And we also have a small capacity for doing direct representation in the areas of special education, discipline, as well as just general access to school. We're a small organization. There's only 4 attorneys, but we are quite active. And actually this, after the first of the year, we're going to start some major trainings across the Commonwealth. We're doing 4 3-day trainings for attorneys. So hopefully that means that you'll be seeing some changes and some good advocacy on the part of your clients, and some information, some knowledge gained by the attorneys that are working with them. So I'm going to go ahead and start the presentation. I do welcome all of you to submit your questions to Janie. I'm used to doing this presentation live, and so I'm more than willing to answer questions live as well, just to clarify. So today we're going to be talking about manifestation reviews. The thing that triggers a manifestation determination review is when a school district is contemplating a disciplinary action that will result in a change of placement. When we talk about change of placement, we think of the 10-day rule. So students with disabilities, so students that have special education plans or who are on 504 plans, can be disciplined the same as their regular education peers for up to 10 days. When I'm talking about discipline, I mean school exclusion, so specifically expulsion and suspension. Any discipline beyond 10 days is considered a removal or a change of placement, and it triggers a manifestation determination. what is a removal from school? So as I said before, a suspension or an expulsion, a removal or assignment to an interim alternative educational setting, and sometimes even an in-house suspension may be considered a change in placement. The situation where an in-house suspension would be a change of placement would be if a child is being kept out of class for more than those 10 days and is not receiving any of the services on an IEP. If they're doing an in-house suspension, but he or she is still getting, special education support and ELA and math and their counseling, then it would not be a change of placement. So that is something where if you have a child that you are working with who says, I'm kept in this room all day, I'm not allowed to be in the general classroom, you want to just ask a little bit more about what they're doing in that small classroom, because we're seeing a lot of in-house suspensions, especially in particular areas of the Commonwealth.
Brenna?
Yes.
This is Janie. I just have a quick question about the 10-day rule.
Yeah.
I know that I've had a lot of surrogate educational parents ask me, is it a cumulative 10 days, or can it be several smaller suspensions that add up to 10 days? And can it be partial days?
Okay.
Because a lot of times our kids are asked to go home or go back to their residences, but the school will say it's not considered a suspension because
right, they call them therapeutic dismissals sometimes, I think.
Okay, yeah.
So it is 10 cumulative days.
Okay.
And technically under the law, the manifestation determination would be triggered if they're being dismissed for related behavior. So if you have a client who is has had three 3-day suspensions for fighting in math class, and then there is he's facing a fourth 3-day suspension, so that would take him over the 10 days, that would trigger the manifestation determination. Mm-hmm. And then in addition, obviously any suspension or long-term suspension, so over 10 days, or an expulsion, which in the Commonwealth can be permanent, would also trigger the manifestation determination. Partial days, those therapeutic dismissals, the Department of Elementary and Secondary Education all actually issued an advisory on partial days, and what they basically said was if it's more than half a day, that is considered a suspension.
Okay.
So if they, dismiss before final period, no, but if it's like before lunch, or early in the morning, then it would count towards those 10 days.
Okay.
So any removal over 10 days of a special education student triggers the manifestation determination review, even a felony complaint suspension. And I'd just like to talk about this a little bit. Massachusetts has a law, it's sort of lingo is called 37H1/2, and that says that if any child has a felony, has had a felony complaint issued against them, that a school can indefinitely suspend them for a time that they determine appropriate if they also think that the student's continued presence would have a detrimental effect on the general welfare of the school. And we're not really sure what that means. It hasn't been very well defined, but just keep in mind that the felony complaint can lead to an indefinite suspension, and the felony can be based on something that didn't happen at school or even during the school year. So if you have a client that was charged with assault and battery with a deadly weapon in the middle of July, that can lead to an indefinite suspension during the school year.
And Brenna, just so that I can kind of make that clear, I have a personal experience with a student who had a complaint of assault and battery with a deadly weapon, and the school said that he could not come back until essentially he pled out, so he did plead out so he could go back to school, but he pled to a felony. And that had very long-term repercussions. So
yes,
that's something that everybody has to be very aware of.
Right. It's a complicated and terrible law.
Yeah.
that we in the child advocacy business do not support. But yes, it is something you really have to be very, very aware of.
Yes.
Okay. So before a student can, or before a school can remove a student with a disability from their current placement, the special education team has to meet, and that is the manifestation determination hearing or review. And during this meeting, they have to talk about whether there is a correlation between the behavior that the student is possibly being sanctioned for and their disability. Because the idea is that we don't want to keep a student out of school for behaviors that are a result of their disability. So the manifestation determination review is a team meeting and should contain the same people that are required at a regular annual review or eligibility determination. So that would be the parent or the SESP, whoever has education decision-making rights, at least one regular education teacher, a special education teacher or provider, the representative from a local school district, professional qualified to interpret evaluation results, other individuals at the discretion of the parent or the school district, and then any student who's over 14 gets invited to the team meetings as well and can participate as wanted. A lot of times during manifestation reviews, we see principals or the deans of disciplines coming to the meeting. They are not required members of a team meeting, and if you are uncomfortable with them being there, I would encourage you to just raise that issue. I don't, sometimes the school will have, oh, of course they don't belong in this meeting, you'll see them later at a hearing. Sometimes they say, oh, well, they have a right to be here. But if you feel comfortable with raising whether their presence is required, I recommend that you do that. During the manifestation determination review, the team asks and answers 2 questions. They ask, is the conduct a direct result of the district's failure to implement the IEP, or does the conduct have a direct and substantial relationship to the disability? At the manifestation determination review, the parent or the SESP has the burden to show that the conduct is a manifestation, which basically means if the rest of the people, like if all the school staff say it's not a manifestation, they are probably going to prevail, and it would be up to the parent to do an appeal afterwards. A lot of times we see schools asking questions that are not part of the manifestation determination review laws and regulations. Some of these questions are, does the child know right from wrong? Is there an exemption from the code of conduct listed in the IEP? Did the student's disability impair the ability of the student to understand the impact and consequences of the behavior? And was the student able to control his behavior? None of these are appropriate questions. And the trouble with a lot of these questions is that, especially if you're dealing with an old student or even a younger student, like when you sit them down outside of the incident, you say, do you know that it's bad to hit your friend? Most kids, or a lot of kids, are going to say, of course I know that's wrong. And then, the school is going to determine that it's not a manifestation. But that's really, really not the question that is supposed to be answered. Just to review, the 2 appropriate questions would be, is the conduct direct result of the district's failure to implement the IEP? Are they not doing something? Is this child not getting the math services that are leading to his frustration and acting out? Or, are they not getting the counseling that they're supposed to be getting 1 time a week? Or does the conduct have a direct and substantial relationship to the disability? Like, is this what we see? Does this client have Tourette's, and does that lead him to, speak out in class and maybe say expletives that are leading to this? There's a lot of ways to. Every case is going to be different, but that is what you need to be considering at these manifestation determination reviews. If the answer to both of the questions is no. So no, it's not, the behavior is not a result of the district failing to implement the IEP, and no, it's not related to the underlying disability. Then the school can proceed with any disciplinary action they're thinking about. They can go over the 10 days of for suspensions, or they can go forward with a long-term suspension or an expulsion. But school districts are still required to provide the educational services for students with special needs, even if they're expelled. So if you have a student with an IEP who's been expelled, they have to get all of the services on their IEP somehow. They cannot just be kicked out of school without any services. So of course that's not ideal, but be heartened to know that they're not just going to be left without any services. This is only true with kids who have IEPs, not kids who have 504 plans. If a student with a 504 plan, if they find out that if they answer no to both of the questions, they can be put out of school without any other educational services. If the answer is yes to either question, so it doesn't have to be both, just one or the other, then the school cannot do any further discipline. And they must take immediate steps to remedy the deficiencies and review. So they have to come back, and they have to, if they are failing to implement the IEP, they need to, put together a plan to start implementing that IEP. And if the behavior that the student is being sanctioned for is determined to be a direct result of their disability, then the school needs to conduct a functional behavior assessment and develop a behavior implementation plan, or they should review and modify an existing plan as needed. A lot of cases, if you have a student that has a therapeutic IEP, if they have a social emotional disability, a lot of times they will have a functional behavior assessment or an FBA and a behavior implementation plan, a BIP. But if they don't, the school needs to put one into action and get that done. So, does the student stay in school? If the behavior is found to be a manifestation, like I said on the last slide, a student returns to school placement. There are 3 exceptions to this determination where a student can be placed somewhere else. That is if the parent and district agree to a different placement. So perhaps during this manifestation determination review, the school decided, we're implementing the IEP, but it's not a great IEP. Let's put him in a different placement, or let's have a 45-day evaluation for him and determine if we need something, if we need to add something, or change his IEP, add services. The other situation is if a hearing officer orders a new placement. So that would be in a situation where there's something pending at the BSEA, which is the Bureau of Special Education Appeals. And the other is a removal for special circumstances. These special circumstances are something that a school can remove a student for unilaterally. They don't need to have the parent's permission to remove the student. And that is if the behavior that led to the pending disciplinary exclusion involved the possession of weapons, drugs, or serious bodily injury. And these are all things that happen at school. When we say serious bodily injury, we're talking about something where a victim would have had to seek medical attention for a concussion, some sort of like stitches, things like that. It's not, just shoving an adult off a shoulder or something like that. It's actually a serious injury. But in these 3 cases, a school can remove a student for 45 days to another setting without regard to the results of the manifestation. So the team might say, we failed to implement the IEP and it's directly related to his manifestation, but since it involved one of these 3 things, we're going to put him in a different placement for 45 days. Generally what happens during these 45 days is that the student will be reevaluated, and then the team will meet at the end of the 45 days to determine whether or not they're going to be adjusting a placement or making changes to the IEP services. These special circumstances in this placement is called an interim alternative educational setting, or an IAES. That's the lingo you might hear schools say. The appeal of a manifestation goes to the Bureau of Special Education Appeals, and that is the administrative body through the the Commonwealth of Massachusetts that hears disputes between parents and school districts around issues of special education and students with disabilities. If you appeal a manifestation, the parent continues to have the burden. So just like they had the burden at the manifestation determination, they would also have the burden to show that the conduct was a manifestation at the BSEA. And there's no time limits on these appeals of manifestation determination other than just the regular statute of limitations, which is 2 years for special education matters. We bring this up because it's related to discipline, and a lot of times disciplinary appeals through schools happen within a matter of days. But the decision to appeal a manifestation is much, much longer than that. Know that if you appeal to the Bureau of Special Education Appeals, the school will be represented by an attorney, and so we always recommend parents or SEFPs to consult an attorney at the very least, or see if a case can be taken by an attorney, because the school districts will be represented by an attorney at the appeal.
And Bruna, just with regards to that, I know that I've talked to DCF on several occasions about the availability of their attorneys should these appeals be made, so that a special education surrogate parent would have access to a DCF attorney if they were to go to the appeals.
Great.
Yeah.
I know that DCF, I mean, they obviously have their own attorneys, but then they also contract with attorneys that do education work in certain circumstances.
Yes. Yep.
So if you are working with, well, you don't have generally any students that are regular education students. Is that correct, Jamie?
It is true, except that I've had a couple of occasions recently where the child has not been is not placed on an IEP yet.
Okay.
No IEP has been signed when they have gotten themselves into some major trouble with the manifestation determination review, and I think that's happening more frequently. You know, that's a question I don't really have the answers to. What are their protections? Do they have any protections? Yeah.
All right. So regular education students can assert the special education protection, so this manifestation review, if the school district had knowledge that the child with a disability, that the child had a disability before the disciplinary infraction occurred.
So if a surrogate educational parent or DCF had already requested an initial evaluation,
exactly,
that would be, then he would be under the umbrella of these protections, right?
Absolutely.
Okay,
absolutely.
That's good to know.
So what is knowledge? So
yes.
If the parent of the child or the SESP, whoever has those decision-making rights of the child, expressed concern in writing, and that can just be, you know, I'm really worried about how Jane is doing in school. I'm worried that there might be some sort of underlying disability or something, you know, keeping them from making progress. Can we talk about it? Or what can you tell them, like, how is she doing in class? If the parent or SESP of the child has requested an evaluation for the child, or if a teacher of the child or other district personnel has expressed specific concerns directly to the Director of Special Education or to other supervisory personnel. The thing with that last bullet is that's part of the law, but it's hard for, you know, surrogate parents or parents to know, you know, what's going on behind the scenes with the school. So, you know, those top two situations are probably what you're going to see and be able to assert in most cases. Mm-hmm. So if the student is in the midst of an evaluation, then absolutely they have a right to have a manifestation determination prior to going forward with a disciplinary hearing.
Mm-hmm. Probably a good reason to have everything date stamped.
Yes.
And hard copies of everything, because it's kind of uncanny how frequently this happens.
Right. I mean, you can request an evaluation, over the phone, but we absolutely recommend people do it in writing, date it, make note of who they gave it to, and things of that. So you can, if you run into an issue, you can trace that paper trail back and say, this is when we did it. We haven't gotten a response, or we signed a consent on this date. Always get copies of anything you sign and give back to the school, because they're not always great about keeping that paper trail.
And I noticed, Brenna, that it's the request of the evaluation, not that anybody has actually signed off on the evaluation.
Yeah, it doesn't have to be the consent. It can just be that initial letter that says, I'm worried that my child or my surrogate student might need more support in school. Can you please evaluate her for special education? So
excellent. Okay.
That protection happens before that consent is even signed.
Good.
So if a child has been through the evaluation process and the team said, absolutely, this child qualifies for special education services, this is what we would like to provide him or her, if the parent or ed decision maker refuses all of those services, then that child does not have protection. So even if the school determined that the child had a disability that was at the level of qualifying for special education, if the parent refuses those services, no protection under the manifestation determination review.
And I think in the case of SESPs, that's probably not an issue. I think we're all trying to get kids services, and refusing is really not in the cards for us. Yeah.
There might be a situation where they're coming on and maybe the child's parent had refused within the last year or something, so they might face that. But I mean, we don't see this very often. If you're going forward with the evaluation, generally the decision maker is interested in some sort of services. So just regarding requesting evaluations after the conduct occurs is not going to trigger these rights under manifestation determination. So let's say in November, the end of November, the student got into a fight and it triggered a the student without any special education services got into a fight and was expelled. You can then request an evaluation for that service. It's not going to prevent the expulsion or trigger a manifestation, but if the student is found qualified for special education services, the school would be obligated to give it to them at the time they find the qualification, even if the student was expelled.
Now, I know I've read some case law about how if the child find, I think that's what you call it, where it was quite obvious that this child should have had services, and if you can prove that, then the expulsion can be overturned. Is that true?
I mean, the possibilities are endless, I would say, when you're dealing with things of this matter. Like, you can negotiate, and if the school is willing to negotiate, anything can happen. I wouldn't rule it out. It's not going to preclude, the school's never obligated to expel a student. Like, there's no regulation or law in Massachusetts that obligates a school to expel a student ever. So there's always room to negotiate and say. So if you are arguing that the school should have known that the student needed to be evaluated, you try that, and they may say, you're right, let's get the student evaluated. Child Find is the part of the IDEA that requires the school districts to have mechanisms that identify students that might need to be evaluated. A lot of those mechanisms are for really young kids that are in Head Start or through daycares and preschool programs for those teachers to identify students that might need like speech and language evaluations and things like that. But certainly it covers students, from age 3 to 21. So if you have a high school student that you're worried may needs special education services but has just never been evaluated for whatever reason, it's always okay to try to negotiate a better outcome than exclusion for them.
Yep.
Does that make sense?
Yes, thank you.
Okay. So that is the end of our presentation on manifestation, and it was quite quick. I'm absolutely, open to answering questions if that's appropriate.
Yes, and if I don't see any questions unless I'm not seeing them properly. No, okay, so there's been no typed in questions. If anybody does have any questions, now's the time to type them in. We also do have the teleconference that will happen on Thursday at the same time, Thursday the what's the 20th, right? From 12:30 to 1:30. And Brenna, you will not be the lawyer who will be leading that. It will be one of your colleagues,
It will be my colleague Marlise.
Marlise, right? And she also has presented this webinar, I believe, or this PowerPoint previously.
Absolutely.
So she's as well versed on it as you are. So just a couple of minutes. I'll see if anybody wants to type in any questions. And use your box. I'm sorry. Yeah, you do have to go onto the, is it on the right-hand side for people that are seeing the webinar? And you can type in your questions under questions, and they will come up and I can see them and pass them on to Brenna. Or it's possible everybody just wants to wait till Thursday. So just a couple of more minutes and then we'll sign off. And I'd just like to thank you so much, Brenna, for your time and your efforts. And
my pleasure.
I know that you do occasionally take clients. Is that true?
We do.
And maybe you could explain a little bit about what that process is.
Sure.
And people go about trying to get on your, I'm sure, waiting list for taking on cases. And we have a bunch of questions coming up now too, Brenda. So I will just go through them quickly and you can go ahead and talk about becoming a client.
So we represent students in school matters. So if you have a student that you have concerns about, like a disciplinary hearing, with or without a manifestation, or special education needs, or just access to school, which we sometimes see with kids who are involved with the care and protection because they may be moving from one placement to another. We are available to take on clients. The clients do need to meet indigency standards, which they generally will if they're involved in the care and protection realm or the CHINS realm, and they also need to be court involved, which if a child is involved with care and protection, they will be. So the students that you work with should qualify for our services in that sense. If you are interested in talking with an attorney, consulting with them just about what to do, or about getting some legal services, you can call our helpline, and that number is 617-988-8460. And you will be speaking with one of our fellows who will get a bunch of information, and then we review calls that come in and determine whether or not we would be able to take them. But we also do advice calls, so if you just have questions, you can call us as well.
Okay, Brenna, a couple of people have asked if this will be available in hard copy, the PowerPoint, and we will put it up on our website as soon as possible. We're a little lax in that right now because we are redesigning it, but it will be up. And if you do want it immediately, just give me a call. My number is 617-399-8341. Again, 617-399-8341. Now, somebody has asked if you could explain the difference between the manifestation determination review versus a hearing. So why would something like this go to a hearing, Brenna? If you could explain that.
I guess, are you talking about a BSEA hearing or actually the disciplinary hearing?
Well, the disciplinary hearing, now you're confusing me, is the manifestation determination review is to determine whether or not the disability was the reason for the behavior. Now, a disciplinary hearing is what? What are you referring to there?
So let me just, I will clarify each of these three things that I'm talking about.
Thank you.
A manifestation determination has been the subject of this webinar, and that is what when a team needs to meet to determine whether or not a behavior is linked to the school not implementing the IEP or is directly related to a disability of a student with a disability. That would happen before a disciplinary hearing generally. Mm-hmm. And so disciplinary hearing would be, we are considering expelling the student for the fight in the math, the fight in the math class. We're thinking about a long-term suspension, a suspension, or an expulsion. Mm-hmm. So the manifestation determination would happen before a disciplinary hearing if it meets that 10-day mark. But then there's also the appeal hearing to the BSEA, which is where you can appeal a manifestation determination that has an outcome that is not favorable to your client.
Can you also appeal a disciplinary action?
You can appeal disciplinary action, and that appeal would go to generally the superintendent of the school district.
Okay.
That's that appeal that you have to ask for, depending on what kind of disciplinary sanction it is, either within 5 or 10 days of a decision coming from the head of the school.
Okay. So that's something that we probably should explore a little bit more because I know that many times, even though the determination has been made that the disability is a manifestation, the conduct was a manifestation of the disability, that the school will go ahead with an expulsion, even though the suspension must stop.
Yes.
Is that true? Okay.
I mean, they're not supposed to. So if the manifestation determines that the behavior is a manifestation, mm-hmm. that there should not be a disciplinary hearing after that.
Okay. All right. Okay. That's what I had understood also.
Yep.
All right. So sometimes, even though the determination is favorable for the student, the school will still go ahead and try to take disciplinary action.
Right. And that's absolutely wrong.
Okay, all right. That's, I think, the point that we need to make.
Yeah.
That is not in compliance with the law.
Yeah.
Okay. And then we have another question here. If a student is 18, if there is a conflict between the parent, now this would be not an SESP but a regular parent, and the student, does the student's decision take precedence? So
before a student turns 18, the special education facilitator from their school, it's part of the transition where you talk with the student about how they're going to deal with their, becoming the age of majority. Mm-hmm. And the student has 3 choices regarding his special education rights. He or she can take over them and be the decision maker. The student can leave those decisions with the parent, or he or she can share them with the parent. Mm-hmm. So it really depends on what the student decided. I would say that, let's say the student decided on his 18th birthday that he was going to have mom make the decisions. He can, because he's the age of majority, he can change his mind at any time.
Okay. All right. So even though he gave mom the ability to kind of co-sign on things, he can rescind that at any time.
He should be able to rescind that, yep.
Okay. All right, and we have one more question here. It says, please explain more about a hearing officer recommending a different placement for a child who is found to have a manifestation.
Okay. This, in certain cases that are, involve a student with a special education plan, with an IEP, and discipline, a school or a parent can file at the BSEA either to contest a manifestation. There are also other situations that are just beyond the realm of this conversation. Mm-hmm. But if, during that procedure, a hearing officer determines that a student, shouldn't be staying in a placement, in his or her current placement, that hearing officer can order the school to move him or her to another placement.
Okay. Is that common? Is that?
It is not common. I have never experienced it,
okay.
Which makes it difficult for me to explain. There's a bunch of different ways that we could get to that situation, but it is not common. No.
Okay. Yeah. Okay. Those are the questions I have. Again, call me if you need the PowerPoint immediately, or else it will be up on the on our website. And again, my number is 617-399-8341. And Brenna, you might just repeat your helpline number.
Absolutely.
Or your number for advice. I liked that one.
I will also add that we have a lot of resources that I think might be helpful to your surrogate parents. We have a community notebook that talks about all things education, it speaks about manifestation in more of a anecdotal way. It's not a PowerPoint, but it has a brief article about manifestation. We also have quick reference guides that might be helpful to your working with the kids that you do. And so you can also call our helpline number to request those, and that number again is 617-988-8460.
Okay, thank you so much. We don't have any more questions coming in, so I'm going to sign off. This is your last chance. If you have a pertinent question, to type it right in. Otherwise, we will be hearing all of you or talking with all of you on Thursday at 12:30 on the teleconference. And thank you so much, Brenna.
Thank you.
And John, thank you.